Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the Edwards Wildman Palmer Law Firm in Boston. The IEEE is presenting this podcast in conjunction with a column that I co-author that appears each month in the IEEE's Computer Magazine. That column discusses legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, we discussed some aspects of employment law that are particularly relevant to startup companies. In this podcast, we will discuss some issues regarding the patenting of software, including software related to bioinformatics that we covered in our January 2013 column in Computer Magazine. Joining me today for this podcast is my colleague and co-author, Ralph Lauren. Ralph is a partner in the Boston office of Edwards Wildman Palmer. Welcome, Ralph.
Thanks, Brian.
Ralph, in our January 2013 column, we discussed how to protect bioinformatics using the laws of intellectual property. But let's take a step back and consider bioinformatics to be a specialized type of software. If you want to protect your software, your usual methods to do so is by getting a copyright or a patent on it. Patent protection for software, however, has come and gone in and out of favor over the years. For example, I can recall instances where the protection seemed to be available only if the software was on a tangible medium like a CD. And of course, every country has its own views on patents that cover software. In the U.S., where do things stand today as far as the patentability of software?
Well, that's a very confusing issue, Brian. The patentability of software per se is something that has changed and evolved. It's clear that the algorithms, the underlying code, that's the underlying way of you doing this, is not patentable. However, there are uses of the software, and as they're applied software, that is patentable. There was a case not too long ago called Bilski, in which the Supreme Court of the United States ruled that a test, which they called the Maschiner transformation test, and was applied below as the sole way to protect software, protect something, was not sufficient. You could have that, and that was okay to use that test, but there are other ways of protecting it. Basically, it doesn't have to be specifically tied to a machine or specifically transform aspects, but it's not clear exactly where that limit is drawn without that type of specificity.
Well, to expand on that machine or transformation test, would that be an instance where either the software is literally being tied to a particular machine, such as a computer that's performing the steps, or that is responsible for, as you said, the transformation test, converting some form of matter into another, like finishing some type of machine goods or something like that? Is that what's meant by machine or transformation?
Well, the first aspect, the machine aspect, is a special purpose computer. It can be some sort of device that uses software, like a computer-controlled aspect for a machine that generates something.
Like a lathe.
Like a lathe. It could be anything along those lines. In addition, when you're talking about the transformation test, it's got to be that the data is in some way or some other aspect associated with it is completely changed to another format. Normally this is done, for example, a valve controller or something like that, where you're actually letting things in and out using the software to decide when you do it, when you don't.
Okay, so from my understanding of Bilski, the court said that previously the test for whether some software was patentable was whether it satisfied this machine or transformation test that you just described. And the Supreme Court said what? That that does not have to be the only test that would be applied. It can satisfy other tests, or is it more broad a definition for patentability of software?
Well, they basically said that using this test and this test alone was not sufficient, that there are tests beyond that could be used. It did not say that the machine or transformation test is wrong. It said it's just too limiting, that in certain circumstances, software is patentable even if it would not qualify under the machine or transformation test.
Okay, I understand that. Now, what's happening in Europe on this front? Can you get a European patent on software?
again, that's sort of a funny thing. If you look at the European patent law, it says computer programs are not patentable. That's Article 52. On the other hand, applied computer programs have been held patentable. They come up with something they call the further technical result test. Again, it's similar to a machine or transformation type test. It's basically got to do something beyond just running in a computer. It's got to have some other technical feature beyond that to make it patentable.
What about Asia? How did Japan and Korea handle this?
Both Japan and Korea allow software patents, but they are very similar to Europe in a lot of ways. Korea a little broader. They've allowed them a little easier. Japan, which only allows very limited claims in any case, really follows a technical advantage type aspect, and it's similar to this further technical advantage test in Europe.
So it seems like a general principle that overlays all of this in all the different countries we discussed is that the computer program in isolation, which could be nothing more than an algorithm or just a series of isolated steps that are performed sequentially, say, in a computer, that could be problematic when it comes to getting a patent. It seems that you do need something maybe a little bit more than just a pure algorithm to justify getting a patent.
You clearly need more than the pure algorithm. I mean, that's basically going back to the U.S. and talking about that for a minute. There's been a recent case called Prometheus, which deals in the biotech area, and it's dealing with natural laws and whether something is a naturally occurring item. But they keep on coming back to the general case law that talks about things that occur in nature or algorithms themselves are not patentable. So the algorithm is not patentable. It's whether that application, the software application, using that algorithm then meets some further test beyond that. But you cannot patent the algorithm. That is deemed equivalent to patenting, something coming out of the sun or the idea of man.
You mentioned Prometheus, and with regard to bioinformatics, as Prometheus said, you can't really cover a medical or a scientific idea, law of nature, something along those lines. Can you explain a little bit about the background in Prometheus and what the facts were and how the decision came down? Because it might have some applicability in the bioinformatics space.
Sure. Prometheus was basically a case where the patent claim itself, someone had found that if you had really the range of which to give or of amount to give a drug. So what happened is they said if you gave X amount of you gave a drug and the amount in the bloodstream was above a certain amount, give less. If it was below another amount, give more. It was basically saying here's the range of action. And they held that that range of action, just finding what that proper range of action was nothing more than finding a natural law when someone gave the drug. This is where the body would do it to make it effective. And all they did was determine whether you should give more or less, and that was not sufficient to be patentable subject matter. So this never even got to the stage of determining whether it was anticipated or obvious. They held that the subject matter as a whole was not patentable, and therefore it never met even a first test to go on to the next step. And that has an effect in something like bioinformatics and has a big effect on diagnostic testing and things like that. If you're looking at bioinformatics of getting the information from a diagnostic test, that diagnostic test itself may not be patentable. And under that circumstance, this really has a question about whether a computer program that would run this diagnostic test itself could be patentable.
That's very interesting. Thanks, Ralph, for your views on this. Courts frequently issue decisions that reinterpret patent laws with results that can affect whether and how software can be patented. If you're looking to get patents on software like bioinformatics tools, ensure that you're aware of the current state of the law. This is particularly important if you're trying to get the patents in different countries. Your patent attorney can give you an overview of what is and what isn't possible on a country-by-country basis. We hope that you found this podcast helpful in understanding some issues when trying to patent software, including bioinformatic tools. Stay tuned for our next installment in Computer Magazine. Until next time, this is Brian Gaff.
And Ralph Lauren.
Feel free to contact us via email at bgaff@edwardswildman.com.
Or at rlauren@edwardswildman.com.
Thank you.